Hey guys, this is Miss Plaster. Chapter 5 is all about the concept of stop and frisk, and it can be a little confusing, so I want to discuss a couple of things with you. First of all, obviously a stop and a frisk consist of two parts. It consists of the stop, and then it consists of the frisk. The stop allows an officer to do a brief investigation to determine if he needs to take any further action. The frisk permits the officer to do a pat-down of the outer clothing to see if you possibly have any weapons. All an officer needs to have a stop or to perform a frisk is reasonable suspicion. This is not the same thing as probable cause. Reasonable suspicion is less than probable cause. For example, if you were in my class taking a test, and I see you look at your phone, put your phone down, and write down an answer, and then you pick up your phone again, you look at it, you set it down, and you write down an answer. As a college professor, I have the suspicion that you're using that phone to cheat. I don't have anything concrete. I don't have any solid proof, but I have a reasonable suspicion that you're cheating on an exam. Now, let's say that you're in my class and you're taking a test, and I see you pull a piece of paper out of your shirt sleeve and start copying down answers. Okay, then my reasonable suspicion shifts to probable cause, because what do I have now? I have a solid fact that is sufficient enough on its own to prove that you're cheating. Now, with the phone, it's just a suspicion because I don't see anything. But when I physically see you pull a piece of paper out from your shirt sleeve and start writing down answers, then I have probable cause that you're cheating. Or if I see you lean over to the person next to you and while looking at their paper, you're copying down answers, that also is is probable cause. That's a little more than just suspicion. That gives me a little more than just being suspicious of you. The actual definition of probable cause it was defined by the Supreme Court in Beck v. Ohio, where the facts and circumstances within the officer's knowledge are sufficient in themselves to warrant a sensible person of reasonable caution in believing that a certain person is committing or has committed a certain offense. Okay? You have a fact, you have some solid circumstance that on its own gives you probable cause and would give another person that's not in law enforcement the same conclusion. Okay? If I had a substitute come into my class and give a test and she saw you pull a piece of paper out and start writing down answers, even though she hasn't been a college professor for a while, that would lead her to the same conclusion that I would have. That would lead her to believe that you're cheating. That is probable cause. Reasonable suspicion is less than that. It is basically just that, a suspicion of the police officer that something is not quite right. I want you all to please be sure and read Terry v. Ohio, which is on page 138 of your textbook. That is the case law or the precedent for reasonable suspicion and the stop and frisk. That is when the Supreme Court gave authorities, or gave law enforcement rather, the authority to perform a stop and frisk based on reasonable suspicion only. Probable cause is not needed. Now, if an officer performs a frisk and he feels a lump or a bulge that could reasonably construed as a weapon, he then has the right to open up the clothing and retrieve whatever that may be that he has construed to be a weapon. If, however, he does not feel that lump or bulge, that could be construed as a weapon and goes inside your clothing, then a Fourth Amendment violation has occurred. Now, people ask me all the time, can an officer stop me and order me out of the car? The short answer is yes, he can. Not only can he order you out of the vehicle, but he can also order your passengers out of the vehicle. He can also do a frisk or a pat down on each one of you. This goes towards the officer's safety. And the Supreme Court has become really lax with the frisk part of the stop and frisk, simply because there are so many officers in the United States that are being killed in the line of duty now. We had one just a couple of years ago in Truman. We had two that were killed a few years ago in West Memphis, all on routine traffic stops. So the Supreme Court is giving law enforcement a large amount of room to perform a frisk strictly for the safety of the officer. So while they cannot do an evasive search, such as inside your clothing, it is permissible for them to do a short, very brief frisk of the person strictly for safety reasons. Read Terry v. Ohio. If you have any questions about reasonable suspicion or probable cause or any material in this summary, please shoot me an email or give me a call, and I'll be happy to discuss it with you. Thanks. You guys have a great week.